I'm here, Your Honor.
All right, good morning.
Good morning.
Mr. Derby, are you here? He was going to call in. All right, we're going to have to bounce around a little bit. Mr. Mills, can you hear us now?
Yes, Your Honor.
All right, good. So we can go forward then. We have Ms. May and Rebecca Mills here.
Yeah.
All right, today we were going to handle a number of property issues. I don't know if you have a pen and paper, but I went through the file and I was going to list all of the issues that we've put over for today. So let me go through. Go ahead.
I don't have a pen. I don't have a pen and paper right now.
All right. Well, let me list them and then I'll go through them one by one. Okay.
Your Honor, if I could interrupt, am I going to be needed for this hearing if it's only property?
Well, do you have any update on the visitation with Mr. Mills?
The only update I have is I provided a copy of the hair follicle that Mr. Mills completed, which was clean. And so that's probably one of the things you guys will be addressing. I have not been able to do another drop-in, but I hope to get that done and be able to wrap up the report as discussed last week. So outside of that, that's the only update I have.
Ms. Mills has indicated to me that she'd like to have a 17 panel hair follicle test done. Is there any benefit to that over the one that was done by Mr.
So her request is to see if there are any steroids or those types of substances. I don't have any objection to that. Mr. Mills might, but I would say that it would need to be paid for by Ms. Mills. The previous 12 panel was clean. It was provided timely. I don't have any indication in the information I've seen from Mr. Mills other than Mrs. Mills's allegations of illegal substance abuse that would involve other substances besides narcotics.
Okay.
So I know there is a history of that. Mr. Mills has admitted that, but I haven't seen anything that would say there was recent use at this point.
Okay. All right. Thank you. I think that's all we'll need from you on this matter. Okay.
Thank you, Your Honor.
All right. Let me go through the list that I wrote down. Ms. Mills is requesting a 17 panel hair follicle test. There's the issue of the insurance for the Kia Soul. Mr. Mills is requesting that Ms. Mills pay $1,128 for the insurance. Mr. Mills is asking that Ms. Mills pay $430 for the hair follicle test that he just took. There's a child support issue that is going to be dealt with by the state. There's the issue of communication between the parties. It's now going through Robert, and the request is that we move away from that communication. There's a question of where the money from the tax return went. There's a question of whether the car was refinanced. There's a question of adding $5,000 to the credit card. There's an issue of the car payment of $389.38 for the Kia Soul. There's a request that Mr. Mills take anger management and parenting classes. There's a request that Mr. Mills do a domestic violence evaluation within 60 days. There's a request by Mr. Mills that Ms. Mills remove her name as the primary on the PUD account to the house. So those are the issues. I'm going to try to go through those as efficiently as we can. So let's go to the first one, the 17 panel hair follicle test. Ms. Mills, do you want to address that? So I can hear you now.
Okay, I'm sorry. About the 12 panel drug test, I guess I'm just very disappointed that a drug test was recommended that didn't even test for the drugs that were concerning to me, that I have proof that he's using. And I think it was yesterday, I submitted recent photos from I think it was June. It was June or July of just this last year of Sam still using steroids. In my heart, I mean, I've been with this man for 7 years. I believe that he's on his best behavior because he's being investigated. There's been issues from this drug use. 7 years. It's a long history, and I don't believe it has stopped. I don't. I think that he needs treatment for it. He has body issues. He is a skinny man, and he wants to be big and muscular. That's his goal. I mean, I don't think I should have to pay for that test. It doesn't even test for what he has taken. He admitted to taking morphine in court. I think it was March 1st or 3rd. He admitted to taking it. That's illegal. Getting drugs from someone, a prescription drug from someone and taking it is illegal. He admitted to that in court, and I don't know why he wasn't tested right then and there. Why did that not happen? The 90 days has passed to where that would even show up on a drug test. So I'm very frustrated.
All right, thank you. Mr. Mills, any response?
Well, if I must take another drug test, I'm fine with that. But I mean, I miss work for this and I live paycheck to paycheck. I had to borrow money to pay for that last drug test. If I need to take another one and she wants me to, I just want her to pay for it. If it comes back with a positive, I'll pay for it. But I mean, I know it's going to come back negative. I can't afford this.
All right, well, Mr. Mills, you've indicated that you're willing to take the test. I think in order to get this done as quickly as possible, I'm going to have you pay for it initially. If it comes back negative, then both of these tests would be the obligation of Ms. Mills to pay.
Your
for.
Honor,
I
I can't afford to pay for these. And if Tina Day isn't concerned that he was using it back in June or July and that he has stopped just for the sake of this investigation, I don't want to pay for it either. You know what? I know in my heart what he's done and he does too. But I believe he will pee clean or test clean today.
Okay, then I'm not going to order the 17 panel hair follicle test.
But I don't feel good about paying for that other test because I don't know why it was recommended by the court if it didn't even test for what I was concerned about. I don't know anything about drug tests.
Okay, we'll get to that issue in just a moment. The second issue is the insurance on the Kia Soul. Mr. Mills, you are requesting that Ms. Mills pay $1,128 for the insurance.
Correct. When Rebecca took the car, I told her it had no insurance and I needed to try and sell the car because I couldn't afford it. When she left me, I was unemployed with thousands of dollars of unpaid bills. And I understand that she needed a car, but then when she had a car provided for her from her boyfriend, she still kept the car and then came to court every hearing saying how badly she needed it, despite it was just sitting parked. And she kept it just to be vindictive and hurt me financially. She only kept it to do that. She had no use for it. So in this time, when I could not afford it, I could not pay for it. It had no insurance. So Red Canoe Credit Union added their own insurance. They put a 6-month premium. And when I got the car back, I put on the cheapest insurance I could. And they refunded me 3 months of that 6 months. But the car was not in my possession. And Rebecca held on to it just to financially hurt me. I don't think I should be responsible for the insurance that was added on top of the loan in this time.
Ms. Mills, any response?
When I had taken the car, it did have insurance on it. I think I had it for a month or two before he took the insurance off of it. He even asked me to pay half of his water bill that he accumulated, him and his girlfriend, in our home, because he said, I'm paying the insurance on your car. Can you help me with the water bill? And I said, no, I don't have money. I don't have an income. I don't know where he thinks I have this money from that I never had. I don't have money. I don't work a job. I don't. He also threatened that the car was going to be repoed, that he was just going to come and take it. He did threaten that there was no insurance on the car, but he was making a lot of threats and they didn't come and take the car. So I found out that there was no insurance on my vehicle on the Kia Soul. I don't remember what month it was, but I got a flat tire and I was out of town with the children and I was stranded and no insurance. I believed that was just another threat that Samuel was making.
All right. So what's going
Also,
to happen?
I'm sorry. I did not sign on that loan that says you need to keep insurance on your vehicle. Samuel made that agreement with the bank. I didn't make that agreement.
Okay. So in the future, this case is going to go first to a settlement conference. And then if you can't resolve some of the property and debt issues, then you'll need to go to a trial in order to resolve that. And there will be lots of pieces at the trial in terms of how the debt gets allocated and how the assets get allocated. What I'm going to do on this insurance issue is defer it to be resolved either at a settlement conference at a trial when lots of these issues can be looked at once. So I'm not going to make a decision on that today, but it is something that can be brought up later. The next issue is the $430 for the hair follicle test that came back negative. Mr. Mills?
Well, she says she has no money, but she's willfully unemployed. She is a licensed cosmetologist. She has childcare. There are people who can watch the children for her. She can have a job if she wants a job. It's just very convenient for her to not be employed. And the hair follicle, the agreement was if it came back negative, she would pay for it. I had to borrow money and take time off work when I'm living paycheck to paycheck to get this done.
Ms. Mills, I know you've argued that you shouldn't pay for a test that didn't test for what you were concerned about.
Yeah, I don't think that I should. That's what was recommended by the court. And I thought that would be testing for what I was concerned about. And didn't even test for the drug that he's admitted to taking.
All right. The order that I entered was that Mr. Mills do a hair follicle test. If it came back negative, Ms. Mills would pay for it. It did come back negative, and so I'm going to enforce that order. I will assess that charge to Ms. Mills. That also may be something that will have to be dealt with either at a settlement conference or at the final at the trial of this case. Let's go to communication between the parties. Mr. Mills, you do not want to communicate through Robert anymore, is that right?
That is correct, but we have just within the past, I think, week or two, started using a parenting app to communicate directly.
Okay, so you started to do that?
Yes, Your Honor.
All right, then I will allow that. Mr. Mills, I will say that the discussion should only be dealing with issues with the children, I believe, with the parenting app, and not other issues.
Of course.
Okay. There's the issue of what happened to the tax return. Ms. Mills, I think you brought that issue up. The question from my notes is whether the tax return payment went to the payment of debts. I've asked Mr. Mills to provide some evidence of that. Again, just to short circuit this a little bit, I'm going to defer that issue for either the settlement conference or trial.
Your Honor, may I say something?
Sure, please.
I did on I believe it was my first financial declaration. I have submitted 3 at this point, but I believe the first one, I have attached my bank statements, and I think I highlighted or underlined where the tax return was deposited. And then within a single day, I spent over what I got in the bills that I had, because as I mentioned earlier, when Rebecca left me, I was unemployed and had thousands of dollars of our bills. And when the tax return went in that very day, I spent every single cent of it on bills.
Can I interject there?
Please.
I went and I looked at the payments that he made, and there's like one payment for a phone bill. There's one payment for Comcast. There's transfers to the vehicle loan. It's his monthly payment. That I want proof that it paid the bills that we accumulated together as a married party. So that was from, I think the date that we ended our marriage, that I left the home, was back in December. He's showing, I'd like proof that those are the bills that I paid, was back from December, not from February. And also one of the bills that he highlighted, I'm looking at it right now, was from the Oasis bar. He spent $79, almost $80, and he highlighted that and added it. So, I mean, he has money to go spend $80 at the bar.
Okay, Ms. Mills, your points are well taken. Again, I'm going to defer that issue, and that'll either need to be addressed at the settlement conference or a trial. But I think being able to trace where the tax return funds went, which I'm sure are community property assets, is going to be important at that point. I think Ms. Mills raised the issue of
Yes.
Mr. Mills refinanced the car. Was that the Kia Soul, Ms. Mills, that you
Yes,
refinanced?
he refinanced it and added on $5,000 from a credit card onto the Kia Soul balance. I don't have any proof of that. These are all in his personal bank accounts. He went and he made his own account and put that Kia Soul in his own private account. He took it from our shared account and put it into his private account. I want to say it was in October, but I'm not positive. So, I mean, it was just months before we split up.
Mr. Mills, any response?
Well, I refinanced that to get rid of our credit card debt so that we had our bills consolidated. So there's just one payment, and that was the Kia Soul. I believe on that first financial declaration, there is all the Kia Soul loan information in there. I'm fairly certain that is there. But I'm not asking her to pay for any of that loan other than what the insurance that was added on top of it was.
Okay. All right. Does that address your issues if he's not asking you for you to pay for any of that? Ms. Mills?
On the balance of the Kia Soul, that's fine. If he's going to take over that, I'm fine with it. But I mean, the insurance is concerning to me. That's his loan. That's his vehicle. He was the one who removed the insurance and didn't put it back on.
Have you provided the Kia Soul to Mr. Mills at this point?
Yes, I did. I believe we had it. I had like 3 days to give it back, and I got it back to him in that time.
Okay. And Mr. Mills, what are your plans with the Kia Soul at this point?
I'm underwater in it right now, so I need to make some payments on it, which is difficult for me right now, but I'm going to pay it down to where I can sell it for what I owe.
Okay.
The car was in her possession despite her already having a car, and the bank added a premium on top of it for the insurance, and I just want that reimbursed.
I understand that. We're going to defer that issue.
Right.
Okay. Are you requesting any car payments be made up by Ms. Mills?
No, I'm not. My only concern is that 1,128.
Okay. The next issue is whether Mr. Mills should take an anger management class. I had already ordered that. And then Ms. Mills has asked that he take a parenting class. Ms. Mills, do you want to address that issue?
Well, which part? The parenting class?
Yeah, the parenting class. I've already ordered the anger management class.
I just know that Sam has put the kids in dangerous positions in our time together, which was a big reason of me being a stay-at-home parent. I did not feel like my kids were safe when they were home with Samuel. One time when my children were 1 and 3, he left them home alone and went to the store that is maybe 3 blocks away. I mean, 5-10 minutes maybe, but a lot of dangerous things can happen in 5 to 10 minutes when no parent is present. That's endangering a child. He's been careless with them. And me being the primary parent and now him having time alone, I think that it's very necessary so that things like this don't happen in the future.
Mr. Mills, any response?
Yeah, well, that was a few years ago, and that was a big mistake. And I recognize that now. And I mean, I recognize that more like earlier, like a long time ago. That was very stupid of me. I went to the grocery store that is like 2 or 3 blocks away to get stuff for dinner that we were missing. Other than that, I completely disagree that I put my children in dangerous positions. As the guardian ad litem has said, she does not believe there's any risk of harm to the children in my care. I think the parenting class is extremely unnecessary.
Can I add something?
Yes, briefly.
Me being the primary parent for 5 years, I have educated myself and taken parenting classes. They have free resources available. I think that even if you are a perfect parent, you can still benefit from taking a parenting class, and you can find free ones. It's just your time and your dedication.
Okay, I agree with Ms. Mills on that. I think there's a parenting class called Children in Between that assists parents in parenting skills when they're going through a dissolution. So I'm going to order that both parents attend or attend that either in person or online. You could contact Ms. Day, the guardian ad litem, and she can help you locate that class.
What was it called?
Children in Between.
Okay, thank you.
Okay. The next issue is a domestic violence evaluation. I think I already ordered that. That needs to be done within 60 days of May 3rd.
I have a question.
Okay, briefly. Yes.
I don't know either.
Are you there?
I'm here. Can you
Oh,
hear
there
me?
you go. Good. You're back.
Okay. I'm so sorry.
What's your
Is that the domestic violence? I can't think of what it's called right now. Sorry. Is that where I go in and I account, what all went on, and then he is counseled according to that? Is that what that is?
What's that called is you provide collateral information,
Okay.
the domestic violence person, and that is something that I think should be done.
Okay, perfect. I
So,
agree.
Mr. Mills needs to let you know who he's being evaluated by so you can contact them.
Okay, thank you.
All right. I think 2 more issues here. One is to have Ms. Mills remove her name from the primary PUD account at the house. Can you do that?
I can do that. Yeah, I can get that done today.
Okay, I'd like that done in the next, well, I'll tell you when we're going to come back. We're going to come back here on June 28th. And the guardian ad litem indicated she'd have a report done by then. Between now and then, I would like the visitation that I've ordered to remain the same. And then we may make some changes, probably will make some changes after I get the guardian ad litem report.
I have a question.
All right, please.
There has been some confusion about pickup and drop off and who's doing that and where we're doing it at. I know originally I was concerned with the protection order, him coming to the house. But then I think you responded and said that we needed to do it at Angela's house. His sister, she no longer wants to be any part of this. I'd really like if he could pick up and drop off at our home. Can we get that ordered?
Mr. Mills, any response to that?
I mean, I don't see why it can't be flexible. We've been doing at Target, which is a good middle spot for both of us. And again, I struggle to pay my bills right now. So, and gas is a big bill of mine because I work in Oregon City. So I'm spending almost $200 a week in gas. So, I mean, I don't mind like every once in a while picking up from her place, but if for the most part we can meet at Target, that works a lot better for me.
Any objection to Target, Ms. Mills?
I have 3 kids and a family. I have to feed dinner at 6 o'clock. That's a horrible time. I aside from my kids, I also care for another child. He doesn't have any responsibilities outside of picking up his kids and dropping them off. And I also would like to address that since our last hearing, Samuel got off work late, and he wanted to pick the kids up late. I mean, like an hour and a half late. That is their bedtime. So if Samuel, for any reason, can't make it to pickup time, is there a time cutoff we can enforce? My kids are in bed I put them to bed at like 7:30. And I think that keeping their routine is so important. They're going to be going to school soon. And Samuel didn't really seem to care. He just wanted his time. I offered to meet him. I said, if you can't make it by 6:30, I can meet you at 10 a.m. the following day. And can we enforce something like that for future pickups?
How far do you live from Target?
3 minutes. 3 miles.
Okay. All right, Mr. Mills, I'm going to have pickup and drop off at Ms. Mills' house. I think the cutoff time would be the kids' bedtime.
Okay.
If you make it before their bedtime, then the visitation goes forward.
Okay, so would that be 7 p.m. then?
Mr. Mills, go ahead.
I believe we've been doing 6 o'clock pickup and drop off, and I think, I don't know what law it is, but I think that in Kelso Longview area, I have an hour window to pick up my kids. So as long as I make it by 7, I'm fine.
Well, that appears to be their bedtime. So if you want to have that flexibility, if you're there after 7, then it would have to be the next morning. Okay. All right. All right. I think I've addressed all of those issues. We'll see everybody back here on June
Your Honor.
8th.
I
And then I'll probably have you set this case for a mandatory settlement conference at that time.
Okay.
Your Honor,
Yes, sir.
I believe and I'm sure it's going to be pushed off to the settlement, but there's also the issue of the credit card debt.
That is something I'd have to defer to that time and address that. So that will be, 2 months away or so. Certainly the settlement conference will come up fairly quickly when you can discuss that. Okay.
Your Honor.
Go ahead.
One last thing. I have video, audio of some of the abuse that took place that I'd like to share with you. I don't know how to get that to you, though, how to submit that to the court.
So typically what you would need to do is drop that off as a thumb drive.
Okay.
Clerk's office, and provide a copy to Mr. Mills.
Okay.
And do that so that I can review it before the hearing.
Okay, perfect.
And I have to review it on a computer that's not a county computer. So I have to do it on my home computer when something comes from outside of the county. So that's why I need it dropped off sometime before and then provide it to Mr. Mills.
Okay.
Okay.
I'm here.
Okay. Thank you both. And we'll see
I'm
you
here,
back
Your
on
Honor.
June 20th. All right, good. And looks like Ms. Height is here. So did you get the report from Ms. Height?
Yes, I did.
Okay. So looking at the file, it looks like you're going to trial on the week of July 3rd. It looks like Tristan made one call on May 18th and did not make any other calls. There was some indication that Mr. Derby was close by during the call, which was not what I had ordered.
No, Your Honor.
Let me tell you what my thought is here, since we're coming up on trial in a little over a month. And since Tristan has indicated a reluctance to talk to Miss Vianola, at this point, my intent would be to leave the telephone calls required every Thursday, that Tristan initiate those and Mr. Derby not be in the vicinity when those occur. And then you'll need to go to trial to get a more permanent order relating to the parenting plan. Any response to that, Ms. Vianola?
Absolutely. I have not spoken to my son, but one time, or I'm sorry, twice now. And both times dad was there. And the last time I spoke with him, spoke about.
How do you know dad was there?
I can hear him. And then after I spoke to Tristan for about maybe 5 minutes, if that, I said, well, can I talk to your dad? And he just basically handed the phone to his dad. And Tristan told me, that's my dad watching basketball. He does not have the wherewithal to go outside, because as much as Dawn says it's Tristan's choice, it is not Tristan's choice. I think our parenting plan that we have now currently has been 5 years, a little over 5 years. Tristan has never made one phone call to our home from his father's house, even though he's supposed to once a week. And that's because he doesn't get to make choices. It's always dad telling him what he can and can't do. And he's not going to disobey his father. And the other problem I'm really having with this is that I lost all contact with my son completely while Dawn was in contempt of court, and he went and got a court no contact order, which got him out of trouble of not following the parenting plan before any of this started. And now Mr. Derby and I had started talking about a parenting plan, working on what was best for Tristan. And he put in that parenting plan, he has zero cares or concerns of neglect, abuse of any form in my home. Yet he called CPS and reported I beat him immensely. Like, I just can't even believe that another parent would make something up like that. But now I am safe and I am secure to have my son in my home as long as I sign the parenting plan that him and Tristan came up with. And I feel like I'm being blackmailed because I haven't seen my son now or talked to him in going on 5 months. And I didn't do anything to get him taken away. CPS had no finding. And I don't even get supervised visitations, and I did nothing wrong. So, and I've said that almost every court date. And I don't understand how Dawn can say, I'll get rid of the parent or the no contact order if you sign this piece of paper. But I can't see him, and I'm not going to talk to him on the phone because he's not going to call me and talk to me in front of his dad or have a normal conversation. And our relationship wasn't broken until the courts continued to allow this to go on. So I have some serious frustrations. Sorry if that comes off harsh, but I'm very, very frustrated because there wasn't a broken bond between my son and I. I had him every other week for the last 5.5 years.
Okay. Mr. Derby, any response to any of that?
Yes, Your Honor. For one, Tristan has his own phone. He has it at school right now. I do not monitor his phone calls to his mother. Last Thursday, he did not make a phone call because the week before that, she had called him, said that she was going to agree with a 1 weekend a month parenting plan change. Then the following couple days later, she said she wasn't going to do it. So then my son got very upset, said, yep, my mom's lying again. And so then he did not want to call her. So, and I'm not going to force him to call her. He is very adamant, Your Honor, on there's something between them that has occurred that he just does not want to even look at her. And so I don't know. I don't know exactly. I'm sure Ann probably has more of that insight than even I. And also, Your Honor, as far as everything that the courts have asked us to do, the respondent has failed to take a mental health evaluation. The respondent has failed to take a hair follicle test. I have done everything the courts have asked, and I feel like she's not cooperating with the courts enough. And as far as Tristan's concerned, he does not want to talk with her, even on like a chat Zoom. So I feel there's something more serious than what she's acknowledging.
How does he not want to talk to her when it sounds like he was agreeable to a 1 weekend a month visit?
I believe it was because of her verbal agreement to him that she was going to agree for a new parenting plan, and he got excited. And then, like I said, a couple of days later, she changed her mind, and then my son got upset, said that he didn't want to talk with her because all she did was lie to him. I do not sit by his room or anywhere close to him when he's talking on the phone, so I don't know where that's even come from.
Can I say something to that?
Let me hear from Ms. Height first, and then I'd like to hear from you. Ms. Height.
I detailed my concerns in the information I forwarded to your honor and to the parties. Hearing this morning and I haven't spoken with Tristan lately. We've had a couple of brief text exchanges. When I spoke with him at his home, at his dad's home, he and I were talking about some options that he was interested in. And it was a fairly congenial conversation. We didn't come to any conclusions. And I let him know that I was not the one that made that decision, nor was he. Hearing this today, it sounds to me like Tristan is way over involved in the moment to moment conversations and decisions that are possibly being made regarding a parenting plan. The fact that he talked about it one day and then 2 or 3 days later was upset because something had been changed. I don't believe that he should be involved in that level of participation. I think at his age, there are some things that he could be concerned about or be included, but this day-to-day back and forth is not good for him, and it's upsetting to him. I hear Mr. Derby's concerns about participation, and yet he himself has refused to follow your orders twice to take a UA. His response to me was that he would not take a UA until Melanie had her hair follicle test done. That was in total defiance of your orders twice. He also indicated that he would not believe a report of a UA from her because he felt like she would, as he put it, trick the system or trick the test. He's really been self-serving in that. And it concerns me that on the one hand, he is very, very interested in what she is doing, and yet he himself has not followed the orders that you clearly have stated twice. And it feels like Tristan is being put in the middle, and these volleys are fired back and forth across him, and he is becoming collateral damage. I don't even know what to suggest going forward. I realize it's going to have to go down to a trial probably. I feel like Melanie has done what has been asked of her. We decided at the last court hearing that because the alcohol had been a problem, and the alcohol was what Tristan was talking about as a problem, she did follow your requirement to take that test. She has not done the evaluation, but she had indicated to me and to you when we spoke about this in court I don't know how many weeks ago now, that she was reluctant to do another evaluation because she had done one fairly recently, and I don't know when that was done, and that she would get that information to me. She has not gotten that to me yet, and I don't know if that's because the provider hasn't been in contact with me. I don't know where the breakoff of that was, but there is some information that's out there already. So it may be, given that information, that she doesn't need to do one. I just don't know that yet. I don't feel like her refusal to do that was a defiant act. I think it was more of a misunderstanding of how that information that's already available could get to me. So, and at this moment, I don't know exactly what that would require, if she maybe hasn't signed an ROI, or sometimes the provider is slow getting it out. I just frankly don't know, but I do have some concerns. I am concerned that Tristan, when I talked with Tristan, he was amenable to having contact with his mom, to having phone contact with his mom, to having visitation with her. He also likes to visit with other members of that side of the family. And right now that's not occurring. And I think something needs to be done to establish a bond between he and his mom. And I think that can reasonably be done. I just, at this moment, don't know what the path forward is. He's a complicated and loving and lovable young man. And I really feel that he needs to have healthy contact with both parents. I'm uncertain how to go forward. I understand you're thinking of staying with phone conversations until some further court action is taken, and that maybe that's the best we can do right now.
Thank you. Mr. Derby, excuse me, Ms. Vianola first, and then I'll go to Mr. Derby.
Well, as far as the mental health evaluation, I've been seeing a psychiatrist, health center. I did sign the ROIs.
Okay.
I didn't understand that I needed to get them to her. I just thought if I signed them, she had access. So now that I know that, because I think that got cleared up when I talked or saw her text message the other day, that I can have that sent to her. And if it's not, up to date, I have no problem in going and taking another one. Already called and figured out. I just walk into Columbia Wellness and do that. So I have no problem with that whatsoever. But if what I have already, which is years of talking to somebody, might be better than just a, new eval. But anyways, like I said, I have no problem with that. And as far as once I talked to Tristan, and I believe it wasn't last Thursday, it was the Thursday prior, I have not had any contact, no text message to Don. I have not responded to his text messages. I have not responded to his mom's text messages about anything because I thought I made something really reasonable with Don, and it was every other weekend. And there's only 2 years left of holidays, every other holiday, 3 weeks out of summer if he had the majority of custody. And I think that's very reasonable. And it wasn't good enough. And nothing I offer is going to be good enough. And I don't think it matters what's on paper to Don. Don is going to do what he wants to do. And I hate to say that. And that is, yes, I did talk to Tristan about what it looked like to him. I think I mentioned that. I normally never talk to him about anything to do with this because I know it's been a ping pong. And I've always felt that his dad is using him as a tool against me. There's been a lot of abuse between our relationship. It's why it didn't work. And I know he cares about Tristan, but his meaning is he's trying to erase me and my family from Tristan's life. Tristan has had zero contact with my father, my biological father, and he used to spend every day after school with him on my weeks. Not one phone call or text message to him at all. And that can't be because Tristan's choosing that. I just don't believe that at all because he has such a tight bond with all of us. And to not even talk about his animals. I mean, we have his dogs, a turtle, you know, all these things, and he doesn't talk about any of them. And none of that makes sense to me other than somebody is implanting things in him. And the hate that Don harbors for me is unbelievable.
Let me hear from Mr. Derby. Okay. Mr. Derby, briefly.
Your Honor, I feel that I have complied with the courts. The biggest issue that we've had with the respondent is her drug usage. So I'm a little concerned with Ann's thinking on just alcohol with the respondent because that was never the problem. The problem with the alcohol was when she mixes the pills and the alcohol. That's when the problem becomes. As far as Tristan was just at her mother's home this last weekend. He spent 2 nights with them. He got to see his half brother. And I'm not telling Tristan he can't go to any family members. I'm not telling Tristan he can't call anyone. I don't know where this is even coming from. Everything that we're doing here with the courts is because Tristan has asked, and this is why I've continually have come to the courts, is because of this continuation of the same problem. And Tristan is the one that's suffering here. And what the last phone call he had with his mother was how he found out about the possibility of a parenting plan change. It did not come from me, Your Honor.
All right. Thank you both for your comments. There's still some information that I think Ms. Height needs. She needs to get the records from Columbia Wellness. That needs to be provided before the week of July 3rd, when this case will be set for trial. Again, going between now and July 3rd, and I'm doing this because I want to give Tristan some sense of control over this. I want him to make phone calls to his mom every Thursday. I suppose if he absolutely doesn't want to do it, he won't. But I would like Ms. Height to indicate that the court would like to encourage that. In terms of what the ultimate parenting plan is, I can't require the parties agree to that. That's something that you can agree if you want, and sometimes it's better if you do, but ultimately you can bring that before a judge and bring that issue to trial. So,
Your Honor, we did make a rough draft for a new parenting plan proposal, which we gave her a copy of to see if she would agree to it. And basically, we wrote everything that Tristan was asking for. He wanted 1 week in a month, and he wanted to see anyone on the holidays as he wanted to see them. Basically, I was trying to leave it to where Tristan had more of the say in the new parenting plan.
Okay. One of the things I'd like between now and July 3rd is to not have any discussion with him about the parenting plan. He's made his thoughts known to Mr. Derby at this point. If there is any discussion, it must be just between Mr. Derby and Ms. Vianola. So no discussion about parenting plan. Telephone calls are encouraged every Thursday, and the parties will go to trial again the week of July 3rd.
Can I ask something really quick? Even sounds like you've made your decision, but is there any way that if Tristan does go to my parents' house, that I can have at least supervised visitations. If he's allowing or okay with 1 weekend a month in a parenting plan that he rough draft up, is there no reason why I can't see him at my parents' house?
Mr. Derby, I'll let you respond to that and then I'll go forward.
Well, Your Honor, the restraining order is in place because of the actions that the respondent has taken. I feel right now Tristan would absolutely probably say no to this.
Could you explain that I did though?
But he does go and see her parents. I've asked him if he's wanted to talk or see his mother, and at this moment he's still saying he does not. I will definitely make sure that he calls his mother every Thursday, whether he likes it or not. I mean, I haven't been doing that, Your Honor, because I've been trying to let him just kind of become his own young man. He's going to be 16 here in a couple months.
Okay, let me address the visits with the grandparents. Again, I don't know enough at this point. I don't think the guardian ad litem knows enough to make a recommendation in that regard. So I'm going to have to deny that and hold that over to the trial.
Okay, thank you.
All right, thank you
Your
both.
Honor, I have a quick question.
Thank you, Your Honor.
Who is this?
This is Bryce Chapman.
All right, what's your question?
Can we move our thing till June 7th? So I have time to respond. I have papers that I'm getting ready to file in by the end of this week.
Your Honor, he had 21 days and you haven't called our name yet. I was going to ask for a default judgment anyways, but it's on our turn.
All right, so Mr. Chapman's asking for a week delay. Is that right?
Yeah, just until the 7th. That way I have time to turn in my papers.
He never
what I'm doing by the
responded.
end of
He
this
had
week.
time. He had 21 days, which is the amount of time they have to respond, and he chose not to.
I received the papers from her 2 weeks ago.
Which is plenty of time.
All right, we're going to go
Absolutely.
for the hearing. I'm not going to continue it at this point, but we're not taking it right away. The next case we're going to take is Kyle Weiss and Carissa Shumate. I know Ms. Shumate is here. Mr. Weiss here?
I am.
All right. Did you receive the medical information that I required last time we were here?
I received notification from Ms. Shumate through text message that she had added me so I could receive medical records at 2 locations. One was Centralia, one was in Longview. However, I believe there's more facilities she's not telling me about due to previous medical records. I don't know why that was disclosed to me in the initial conversation. So yeah, that's where we're seeing that right now.
Do you know, do you have any information about the previous facilities?
Yeah, Ms. Shumate lived in Vancouver for almost 3 to 4 years, and my daughter was seen in facilities around Vancouver several times, and she did not disclose that information to me. She only told me about Longview and Centralia.
Okay.
Your Honor,
Any response? Go ahead.
the one in Longview is the main branch. The one in Vancouver is the same number. So when you call, it's the same number to get to any clinic.
That's the Longview.
Child adolescent clinic.
What is the facility?
The child
Adolescent.
Yeah.
And did she attend that, a branch of that in Vancouver?
Yes.
Okay. Were there any other medical providers in Vancouver?
No, it was just a child adolescent clinic unless she had to go to the ER.
Did she go to the ER?
She had twice
Okay. Where did she go to the ER?
in Salmon Creek.
What is that?
I
Legacy Manual there, or what is the hospital there?
I believe it's Legacy.
Okay. Mr. Weiss, any response to that?
That would be the one that's in question, is the hospital there in Vancouver that was not disclosed initially. And she told me she added me so I could get a hold of records, but I'm not 100% sure if she signed any ROIs to allow that. I don't know if that's been done or not.
You're talking about the child and adolescent clinic at this point?
For every single facility she's had Taylor in, every single one of them.
What have you done to give Mr. Weiss access to these facilities?
I have called them and asked them what I needed to do, and all they said was to add him as the father because he is the father. That once he's on there, that he can just call.
All right. Have you attempted to call any of these facilities to learn about the information, Mr. Weiss?
Not yet, Your Honor.
All right. All right, Ms. Schumann, I want you to do the same thing with the hospital at Salmon Creek. I'm going from memory to say that's Legacy Emmanuel, but it may be in another hospital. Mr. Weiss, I want you to check with the facilities to make sure you have access. And I'm going to put this over for a month. And essentially what I'm putting over is the contempt hearing to make sure that all of these accesses are working. So I'm going to put this over to June 28th.
Sounds good. Are we also discussing the social media today?
Well, I entered in orders that you can access with the clerk's office that gives you authority to take it down.
It's been taken down, Your Honor.
Okay. And Mr. Weiss, if you're not convinced of that, you can come get the order. It gives you the authority to deal with TikTok.
Sounds good.
Okay. Okay. Thank you both. We'll see you back. Shauna
here,
Ray
on
and
the
Jason Chappelle.
Thank you.
I think I saw Miss Ray here. There you are. Good morning.
Good morning.
Is Jason Chappelle here? And good morning, Ms. Smith. So I'm sorry to put this over again, but the guardianship issue is scheduled for June 6th. And I'm hoping that we're able to make a decision in that case on that day. I don't know, Ms. Smith, do you know where we're at on the report?
Yes,
minor guardianship case?
Sure. I'm actually completing the reports for both matters this week. I'd like to get them out to the parties within the next couple of days. As I mentioned, we've had some scheduling issues, and getting the report completed has been a challenge, but I am compiling everything right now, and I have been most this morning, and we'll probably finish up one report later today, and then I'll reconcile the other report. So it would be my request, since the review for the minor guardianship is set for the 6th, it would be my request that we set this matter set over to the 7th, and then they can trail each other.
And that was the note that I wrote to myself. Ms. Ray, any objection to putting this matter over to next Wednesday? And then on Tuesday next week on the 6th, we'll deal with the minor guardianship case and we'll see what happens there.
No, that's fine.
Okay. So we'll put this matter over then to June 7th. We'll see everybody. And the other one for adequate cause. I'm denying Mr. Chapman's request for a continuance. Ms. Chapman, do you want to go forward?
Yes, please. So, Your Honor, the safety of my kids, like any mother, is my biggest concern, as I thought it was always Bryce's as well, at least until the last year of our marriage, when he would sneak drinking every single day, as well as on numerous occasions drive us all 5 somewhere while intoxicated, and I would not be aware of that until afterwards. It all started then, which is one of the things that led to our divorce. After Bryce moved out, he promised he was done drinking and doing cocaine, as my final straw in our marriage was taking our kids to the 4th of July carnival, where Bryce claimed he was only going to use the bathroom and was gone for 15 minutes while the kids got their faces painted and returned with snot and cocaine residue dripping from his nose. So those promises meant a lot to me. It meant maybe we would be getting the real Bryce back. He went to only 2 AA meetings and never returned to another one. Skip forward 1 year to we were going to court, and I end up getting my car back in the middle of going through a custody battle, which here we are again, and finding it full of alcohol, to which he loses most all of his custody. It's been a year since then, and at the time of that court date, he was so upset about losing his time with them, told them he was done drinking yet again, said he was going to fight for them and put them through some very big emotions that they were way too young to understand. What?
I'm muting whoever was speaking.
Oh.
Go ahead.
There's some very big emotions they were way too young to understand. And after a full year, not only has he not quit drinking, not given them a home or beds or any sort of reliability, he doesn't show up to most visits, ignored them, and no called, no showed them for 2 whole entire months, has used only 6 Wednesdays in an entire year, has moved an hour away in that year without letting anyone know. But Your Honor, the worst and most terrifying thing is that I still have to send my children twice a month if he shows up. Somewhere that, rather than feeling happy and excited for them that they get to spend time with their dad, instead I sit with my phone on loud in case I get that call, with my brain constantly racing through every what if, and just hoping that they will, number one, be smart enough in that moment to remember all the things I've had to teach them about what to do if you're about to be in a car with someone who has been drinking, and number two, that they could remain strong enough to do so with it being their own father. And or a lot of weekends, it's a lot of convincing and tears to get them to even go. They fear their own safety as well. They're tired of living in one bedroom, not having rooms or beds, and all 5 of them sleeping in a bed with him and his girlfriend. Brody, the 11-year-old, has tried faking sick on numerous occasions so that he doesn't even have to go. But Your Honor, I have to force my kids into an unstable, unsafe, and unknown situation just because, well, it's court ordered. It's been the toughest thing on us this far. I do have a recording of Harley, our 7-year-old, stating how he drank beer and drove on the weekend of April 29th while driving 4 hours along with his girlfriend, her son, who was 4, and our 4-year-old Tatum in the car. Our son Brody stayed home because it was his first baseball game to which his father didn't attend. I'm sure you're wondering why it has taken me so long to file something, and while it's pretty simple as much as it is complicated, the last thing I want for my kids or Bryce is either of them to have less time together. All I've wanted and waited for is for things to get better. Bryce and I have had many, many talks, one of which my Ring camera on my front door recorded, which I can use because it records a public area, where he admits he has a cocaine and drinking problem, and he states, "I'm getting out of that crap. I'm done with it. I'm done drinking." It's been over and over again. I've been foolishly manipulated by his words and allowed myself to believe them, because if what he said was true this time, then that meant the kids wouldn't be any more affected. Their dad is finally coming back. Unfortunately, the more and more I hear, the more and more the kids talk to me, and the more I see, I just can't sit back as I am. This kid's only advocate. A few hearings back for contempt, you mentioned I should think about bringing the parenting plan back to court. And at that time, little did you know, 2 weeks prior, I had actually retained a lawyer to do that all for me, because I just couldn't handle this anymore. And this was going to be a big thing to tackle, but she was just taking too long. So I had canceled her, got my mom her money back, and decided to take it into my own hands. And then he decides not to respond to anything, but then 2 days before court wants to text me telling him I made him very unhappy and maybe we can find an equal ground, but yet can't care enough to actually respond, but can show up to court, which I just presumed would happen. So with this all being said, I would like a default judgment to be ordered, if at all possible, Your Honor. Thank you.
All right, thank you. Mr. Chapman, any response?
Yes, Your Honor. So my response that I would have for you on June 7th, all my papers I have included, included a drug and alcohol test. I have it scheduled for the end of this week. I was going to include that in the papers. All that being said, this is about, I feel a bunch of retaliation that she's trying to get back at me, trying to get me in trouble, trying to get me to go to jail. She's doing everything she can to find everything and anything for me to be contempt, to where I can be in trouble. That's all she's ever wanted, and that's all she is wanting, is me to go to jail. Just like every other contempt order, she's asking when my penalty is going to happen. My kids love being with me. They tell me every time, and they cry and they're upset when they have to leave, when I have to drop them off. There's no issue at all whatsoever. They tell me that they want to be with me. They want more time with me all the time. So with that being said, I mean, turning in my drug and alcohol test, doing all this, I mean, that's what I was going to have for you on June 7th. But like I said, I just needed another week to do it.
I have a very short response to that, Your Honor.
Go ahead.
My kids get really upset when they come home, because they have so much fun when they're there, because he doesn't get to see them a lot. And they've expressed to me that they're just worried if he's going to show up the next time. So they do get upset when they come home, because they just don't know if he's not going to show up again. And these things, Bryce is very clueless too, just because he doesn't know, because he's the take him and play on the weekends when it's convenient person. So he has no clue about their emotions and their feelings anymore, and what really goes on. So of course, yes, they do. They love when they get to go hang out and play, but I do have it documented, the times when they don't want to go, and when Brody has actually not gone. But that's what that is. They're afraid of him not showing up again. And as far as him submitting any drug and alcohol tests, I mean, it's cocaine. He can pee clean within 2 days, and he's very good at that. So that's fine. And also, I'm not asking him for him to go to jail. So that's far from retaliation. And I can prove when I retained the lawyer, and it was far before any of those things. And I'm pretty sure I have multiple parenting plans that I have filled out multiple times regarding all of this long, long ago. And that's all.
Okay. So one of the motions that was brought was a motion for adequate cause. There was a parenting plan entered on June 15th, 2022, regarding the party's 3 children. And in order to change that, this court initially has to determine if there's adequate cause to make a change. And if there is, then it would be put on the trial setting docket for a hearing in front of a judge to determine if a change should actually be made. I'm not determining that change. I'm just determining whether there's enough evidence to go forward with that. The statute addressing adequate cause is RCW 2609260, and I want to read part of it. So it says the court shall not modify a prior custody decree or a parenting plan unless it finds, upon the basis of facts that have arisen since the prior decree or plan, or that were unknown to the court at the time of the prior decree or plan, that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child and is necessary to serve the best interest of the child. What I've been provided for today is that the parenting plan has not been followed in a couple ways. The Wednesday visits have not been utilized, and there apparently was a long gap of time when Mr. Chapman did not see the kids.
As well as still drinking while he has them.
Okay, it's my turn now. Okay.
Sorry.
There has been some indication of drinking. That's come from the children. I think that's an issue that probably needs to be addressed. But I think simply with the failure to follow the plan, and I'm going to accept Ms. Chapman's testimony about the impact on the children, is that it causes them to be concerned about when their dad's going to come back next. I think that does provide adequate cause, not having to do with anything with the moving party, but having to do with the non-moving party. So that evidence fits within the statute, and I am going to find adequate cause and sign the order for adequate cause. At this point, I'm going to deny the contempt order without prejudice. I think the effect of all of this is that you're going to need to go back to court and discuss all of these issues, and the court's going to consider it in fashioning either a new parenting plan or do something with the current one. I'm going to place this on what we call the universal trial setting calendar. And today's the 31st. I'm going to put it on the universal trial setting calendar for a one-day parenting plan trial for June 14th at 1 p.m. That's when you're going to get the date that this will be heard. So the June 14th hearing will be a fairly short one, just to get a date when it will be heard. I am going to enter one bench order in this case. The current parenting plan is not going to be changed at this time. I am going to order that Mr. Chapman not drive more than 30 miles. One of the issues apparently was a long drive where he stopped to get beer on the drive. So I want to try to address that by putting a 30-mile limit on where he's able to drive with the children, and hopefully alleviate some concerns. So that's where I'm going to go today. Okay. So you'll need to be back in court then on June 14th at 1 p.m.
Okay. And
Okay, Your Honor.
I'll let Mr. Chapman go first. Go ahead.
Okay, so with no more than 30 miles, and I am an hour away, my parents is half an hour away. That's where she was going to drop off and pick up or do whatever too. Can we meet halfway in the middle? And because that's less than 30 miles for me, do like a Woodland Walmart.
Which Walmart?
Woodland Walmart. It's right off the freeway, and it's halfway in between both of us.
Ms. Chapman?
yep, that's what I asked for in the plan.
All right. So you can meet at the Woodland Walmart. All right.
All right.
Okay. And Your Honor.
Yes, briefly.
In the last parenting plan that we had already had prior, he is ordered not to drink, period, when he has them, or 24 hours before. So that contempt, he's not in contempt for drinking with them.
I'm not finding that at this time. That order, however, Mr. Chapman, you need to know, remains in effect.
Yes.
Okay. All right.
Your Honor, I'm
All right.
Chief Lawrence,
Thank you both.
guardian ad litem in the matter.
Mr. Francisco, you want to unmute yourself? Well, Mr. Lawrence, have you been in touch with the parties?
Yes, I have, Your Honor. I had some trouble reaching Mr. Gutierrez. I tried for 3 months to try to get a hold of him through phone calls and email messages, And I finally was able to reach him and had a Zoom meeting with him on May the 17th of this year. I did make a home visit and spoke with Alyssa and the children on February the 1st of 2023. She was having problems coming up with the money to pay my fee, but that has since been resolved. And I have now been able to have a meeting with Mr. Gutierrez, goes by his middle name, Julian, and I met with him. And at that meeting on May 17th, he indicated that Alyssa has since filed a motion to move to Ellensburg. And I've had brief contact with Alyssa about that. Apparently there's some friends or family that live in the Ellensburg area, and I haven't had a chance to explore that fully at this point. So I need another appointment with Ms. Gutierrez, and then I need to go back to Mr. Gutierrez and present to him what her plan is. She's offering to transport the children for visits from Ellensburg, and he lives currently in Vancouver. So at this point, I need some extra time to finish off my report.
All right, thank you. Ms. Gutierrez, can you hear me? Can you unmute yourself?
Yes, I can hear you.
All right, thank you. You brought a motion to show cause regarding child support that's not paid and Mr. Gutierrez not working with the GAL. Do you want to address that motion?
Yeah, so I had done that motion before he decided to finally reach out and work with the guardian ad litem. So that part has been resolved. He is now working with the guardian ad litem. And I've been working with DCS trying to get the child support situated. He's currently caught up except for last month. I just wanted to see if I could possibly get an order to have child support go through DCS from here on out. He needs to work with them because all I get from him is threats on, if you don't do this for me, I'm not paying child support. And that should not be the case. I shouldn't have to abide by his order to receive child support for his children.
All right, Mr. Gutierrez, can you hear me?
Yes, I can hear you.
All right. So I'm glad you're working with Mr. Lawrence. And it sounds like Ms. Gutierrez wants the state child support division to handle child support. I don't know that you have a choice in that matter, but I'll let you respond if you want.
Thank you.
This
is Casey Looney on behalf of the State Department of Child Support. And we will be filing a notice of appearance on this case because Ms. Gutierrez had requested a modification for child support that had not yet been addressed by the court. But we will be entering a notice of appearance to work with the case to figure out how to set child support on this one.
Okay, well, I guess that answers the question, Mr. Gutierrez, that the state will be involved. So that leaves the motion to relocate. Yesterday, I got an ex parte motion to allow an immediate relocation. I held that over to today because this case was coming up. And what I would like to do is put this over 1 week. That's before the move time stated by Ms. Gutierrez, which is June 12th. I'd like to put this over to, I think it's June 8th, maybe June 7th next week, just to address the request to move. I would like you both to get a hold of Mr. Lawrence to discuss your concerns and your issues with him. He has been very helpful to me in the past in sorting out parties that would like to move with the children and determining how to go about that. So I would like you to get a hold of him and deal with that. For today, I'm going to deny the motion for contempt since it looks like the state is involved with child support and Mr. Gutierrez is now working with Mr. Lawrence. And then we'll put this over to June 7th to deal with the motion to relocate. All right?
Sounds good. Thank you.
All right. All right. Thank you. I see there are a number of people looking on who are interested in this case.
You got this.
So we're here to address child support and to check in with the GAL and to look at how visitation's going. Let me turn it over to Ms. Looney first, and then we'll go from there.
Thank you, Your Honor. So back in November of 2022, Your Honor did state that you wanted to review child support in 6 months. That was prior to the state being involved. And at that time, you had set child support at $700 per month based on worksheets you had from Ms. Vaughn. So we had not seen any information in the file in Odyssey from either parent. So we did submit worksheets previously in March. And we have since then gotten some additional information from Mr. Kyoshi about his current employment and his current rate of pay. So we did submit new worksheets that are proposed for the court to consider. The state doesn't have a specific interest regarding the amount of child support that's paid. We do want to have the incomes as accurate as we can have them under the law so that we have accurate percentages for the parents to be responsible for uninsured medical expenses as well as any daycare or childcare expenses. So the current worksheet that we have presented for consideration shows that Mr. Kyoshi makes a gross income each month of $4,868 and his net income is $3,491. We do have Ms. Vaughn at full-time at her current rate of pay. She has indicated to the court previously that she cannot work full-time because of childcare expenses, but because that will be part of today's order, the state is imputing her at full-time at her current rate of pay because childcare expenses is not a reason for deviation under the law. So we have her income at a gross of $2,642 with a net of $2,323. So the resulting payment that we have for child support for Mr. Kyoshi to Ms. Vaughn comes to $622. So we're leaving it up to the court's discretion on whether or not you would change from the $700 to the $622, but that is the information that we have currently.
Okay. Let's just focus on child support now. Mr. Kyoshi, any response?
You're cut out. I cannot hear you.
It might help if you turn your video off.
Can everybody hear me now? Okay. Mr. Kyoshi?
Yes, Your Honor.
Any response to the, I guess, child support worksheets? It looks like your basic child support obligation would be $622 under the current worksheet. Any comment on that?
No, Your Honor, I have bills and I was able to get my paperwork in and Ms. Looney looked at it and I guess that's who came out to 622. I have no objections to that.
Okay. Ms. Vaughn, any response?
Yes. So yeah, they're imputing me at full time, which I understand. It's not the cost of childcare that's the problem. It's my availability to it. Like I've said, I only have one person who can care for Corey and she also works. So I have to work around her schedule in order to work. This affects the proportional share percentages because it then raises my amount and drops his. It also doesn't cover the fact that I am paying for childcare, which I'm paying $200 a month for that is not included here. It also, I understand, doesn't go over the fact that his dad pays for health insurance. I do not know what he pays for the premium just for Corey, which I would need to know. I had talked to the child support office and told them that I would happily put in a proposed worksheet that reflects all of these aspects. I just don't have that information from his father on how much the premium is for the healthcare, which again is what Ms. Looney is saying. They're mostly concerned about that and the child care part of it. Gosh, I can't talk. So if his dad is able to get me like copies of the premiums that he's paying, what portion is just Corey's versus his as well, I can happily put in a new proposed worksheet along with a new child support order.
Are you able to provide the medical premiums, Mr. Kyoshi?
I mean, I was under the understanding that I would turn in all my pay stubs and that Department of Child Support Services would figure all that math out. I don't know what she's talking about. And I'd also like to add that she is getting state assisted. So I think the $622 in her is fair on my part. I do pay to drive down there a week. I pay for gas. I pay for the visits. I pay for the food. I still buy him toys because I want us to play and have a good time. I don't understand. I think I think where we're at is good. Okay. He is under my medical insurance. I think that's all that matters is that he's got medical insurance and and I'm providing that.
Okay. All right. I did order that within 6 months we would relook at child support because Mr. Kyoshi's employment was somewhat in flux and we didn't know exactly what he would be earning. Now we do, and it ended up in a bit of a drop in the child support to 622. I think the worksheets are properly addressed. And so I'm going to order that child support beginning in June be $622 a month.
So, Your Honor, then I would need to submit the child support order, which accounts for the child care portion separate because it's not included in this worksheet.
That's true. Is that something you're paying? You've been paying on your own?
I've been paying the full 2.5 years.
Okay. Are you asking that Mr. Kyoshi contribute to that?
That he pay his proportional share, yes.
Your Honor, the state would draft worksheets, which would include the proportional share requirement.
Okay.
We'll draft an order and send it out to the parties.
How long do you think that will take?
In order to make sure that they have a chance to review it, we would just ask to set it out for 2 weeks for presentation.
if we need to go longer on some other issues here, then we'll address that. All right, Ms. Fellows, have you received a domestic violence evaluation at this point?
Yes, Your Honor. I had received it the day prior of our last hearing, but I didn't have a chance to review it. Or actually, I think I received it the day of. Yes, I have reviewed it. He is recommended, Mr. Kyoshi is recommended for treatment, 26 weeks. A few things out of the assessment summary. Summary of the participant's level of accountability. Mr. Kyoshi is assessed at having a low level of accountability. The motivations and readiness to change. He is in the pre-contemplation state of change. Assessment of the degree of abusive cognitive and behavioral patterns. Mr. Kyoshi would benefit from the core requirements of a domestic violence program with specific emphasis on types of abuse, belief systems, respectful relationships, accountability, motivations for abuse, cognitive distortions, and indicators for using abuse and violence. The rationale and recommended level of treatment. Mr. Kyoshi's interview and supporting documents indicate power and control seeking behaviors and a pattern of abusive behavior. He would benefit most from trauma-informed cognitive behavioral therapy and level 1 domestic violence intervention treatment program, which includes 1 treatment session attendance per week for 26 weeks. Individual sessions may be submitted or added in addition to the minimum required sessions as needed. His treatment completion will be based, excuse me, on compliance with his treatment contract and successfully meeting, excuse me, treatment criteria and core competencies as outlined in his treatment plan. And it is also required and recommended for another kind of parenting classes. It's called a 12-week parenting program that focuses on the effects on children that witness domestic violence. So that is what came of the DV evaluation. So I'm not exactly sure when he plans on getting into treatment, starting the treatment and the 12-week parenting class. I would like to see him be at least, I would say, halfway through the DV treatment and halfway through, if not completed, the 12-week parenting program, parenting class, because the child was a witness to these DV incidents. I think it's really important that Mr. Kyoshi gain an understanding of domestic violence and how it affects his child, and hopefully learn some different parenting skills. At this point, I'm not recommending any changes to the visitation until he does get into those classes. I also do have another issue, is that he has not fully paid for the GAL fees. I have brought this to the attention of court. I have emailed him numerous times now, reminding him about making payments for his balance. He does come down here to Longview for his visitation on Tuesdays. I have let him know he can drop off the payments. I have not gotten any response. At this point, last week I emailed him and said, I need you to pay your balance in full, which is $550. He did not answer that email. He did not come by yesterday or make a payment. So I've been putting a lot of hours and time into this matter, and Mr. Kyoshi hasn't paid his portion. So I'm concerned about that.
All right, thank you. Mr. Kyoshi, why don't I hear from you first, and then I'll hear from Ms. Vaughn.
Yes, Your Honor. So, and I'm sure so she just told you what the treatment plan was. I did file my notes from all the supervised visits, except the last 2, because they hadn't been typed out yet. I feel the visits have been going good. I have no interaction with Alexandria other than on our family wizard, but we haven't even talked on that because we have such a set schedule of the supervised visits on Tuesdays, and then Wednesdays is my FaceTime visits. I have no problem with the treatment if that's what the court wants me to do. I'm willing to do that. I'm still asking for unsupervised visits. Not once since the protection order has been put up have I broken it or tried to get a hold of Alexandria outside of what Corey's times were for visits. I'm not trying to go close to her. I can stay away. Like I stated before, you can keep the protection order up on her. Reading the notes from our visits, we have a good time when me and Corey are together. We have a relationship. And outside of that, I'm not interacting with with his mom. And I've respected that protection order, and I will continue to respect it. I have no need to go near her, and I'm not trying to. I just want to be able to raise my son, and I've said this before. I'm not trying to just pay child support and not be able to take him out to the park. His cousins ask about him. We have, family gatherings that I can't even bring my kid to those. I can do the treatment if that's what the court wants, but I want supervised visits. I want him to be able to see his cousins. I want them to get to know each other and be close. I've done everything that court has asked. I'm not out here not trying to be I'm not going to be made to look like a bad father. I want to take care of my own son.
Okay.
I've done what the court has asked, and now I got another 26 weeks, and then on top of that, the 12 weeks of the parenting classes, which if that's what the court wants me to take, I'll take. But I'm just about to be done with my monthlies next week.
Done with your
the monthlies for the AA.
Okay.
Our last group meeting is next week, so I have no problem trying to find whatever classes I need to do next. It's frustrating. It's been 9 months since this all started. Not once have I gone near his mom. I don't plan on it. The visits have been going great. But another thing is when these supervised visits happen, we can't leave the room. So we're stuck in the room. I can't even take him to the park. There's just four walls, and I gotta find things to keep him entertained, which I have no problem with. But I want him to get out. I want to see him, in the park, running around, other kids playing with his cousins.
Any response?
Yes, so I agree with Beth that I don't like the idea of unsupervised until he's at least halfway through this DV and parenting class program. I do understand that he had said in the past that he did a parenting class, but this one is specific to our case, which is much more important. And even through what he just said at the moment, he's emphasizing how important his family involvement is with Corey, not his own. And he keeps saying that if the court wants him to do this treatment, he will. He's again not taking accountability into the fact that he needs these things, that he's done these things that have caused these issues. As far as him saying he has not violated, so say the protection order, no, the 1,000-foot radius thing was not in place until he showed up at my house twice, not once, but twice. So that is an issue. He, again, is downplaying that. And he is almost done with his treatment program, but he has it's felt like he's scathed by in that program, where he's done like bare minimum, he's got behind, he's almost got discharged twice, and then he's just caught it all up in 1 week. So there's an issue with consistency there still, which I am concerned about even going into this next set of treatment. I kind of want to see that he's actively keeping up on what the court has required of him, not that he's kind of doing bare minimum and sitting back and just hoping for the best and asking for more, that he's actually enthusiastic about doing these things because they do matter. They matter to our future, our son's future, what co-parenting looks like. The protection order is in place because he hasn't acknowledged that he has damaged our family and our relationship in these bonds by being domestically violent and having an alcohol issue. So I do agree with Beth when she said that she wants to see him about halfway through this treatment program successfully before considering unsupervised.
Right. All right. Ms. Fellows, first of all, would you mind emailing that evaluation to my email? I'd like to look at it.
Yes. Can I also need a copy of it?
Okay.
I'm not sure if the mom has gotten a copy.
I have not been served a copy.
Okay. Or if you'd rather, you could file it with the court under seal. I don't know that would not get to Ms. Vaughn. I think Ms. Vaughn is entitled to look at it also. Okay.
So shall I email it to both of you?
That would be fine. So let me start here. I've read the visit notes regarding the supervised visits, and they are glowing, if anything. Mr. Kyoshi shows up with a new set of toys every time he engages. Corey enjoys seeing him. Corey doesn't like it when Mr. Kyoshi leaves and they have to be separated. So I want to acknowledge that. I've read that. That is extremely encouraging to me. And I'm going to keep that in mind going forward. I am going to order that Mr. Kyoshi complete the treatment that's recommended in the domestic violence evaluation. And I'm going to order that he attend the parenting class. Those could be done at the same time if you have the time. They don't necessarily have to be done one after the other. I'm not going to order unsupervised visits at this point, but I think we're getting very close to that point. And I know we've had some hiccups along the way. Ms. Vaughn's statements are correct that there were some issues with compliance with the treatment, but those worked themselves out. And from where we sit today, Mr. Kyoshi has done, as far as I can tell, everything that this court has asked of him, and I appreciate that. And again, the current visits, the supervised visits are going very well. So I'm going to leave the supervised visits in place just as they are. And again, through those, it looks like Mr. Kyoshi is very conscientious about making sure he has no contact with Ms. Vaughn. And so can continue to do that unless it looks like you are communicating or can through the parenting app that you have. I'm going to set this out a month, and I'm expecting at that time, Mr. Kyoshi will be checked into the treatment that's recommended and perhaps the parenting class. I'd like to read more notes of his visits with Corey and then see if we make any kind of move at that time. Okay. All right. So
I had one more thing to add, Your Honor.
Let me just state that that date is going to be June 28th. And I think, why don't we put the child support orders over to that date also?
So we have our supervised visitation set on Tuesdays. For the month of June, I do have a schedule change for the month where I'd be off on weekends, Saturdays, Sundays. So if we can schedule the visits to that, if his mom would be all right with that.
Does the facility provide for that?
No.
I don't know if the facility.
Sorry, Your Honor. I know that Parents Place is not available for weekend visits.
So you work 5 days a week, then weekdays?
Yes, for June, and then I'll go right back to my old schedule. So we just got to figure out if there's a place where we could do visits on Saturdays or Sundays, and then I do that. I just want to put it out there so the court knows that I have a schedule change.
Your Honor, I think the previous supervisor that we were going through, Barbara Brandhorst, she was doing Sunday mornings. If maybe we could get back in contact with her for this month.
And you'd be agreeable to Sunday mornings?
Yeah.
Okay.
I do think we might even allow more than 2 hour window as well. I do think it makes sense to up his parenting time if it's a possibility, but I knew with Parents Place schedule that wasn't an option. But if Barbara's willing to do 3 hours, I would be happy with that as well.
All right. Mr. Kyoshi, do you have a way to get a hold of Ms. Brandhorst?
Yeah, I do. I think I can get a hold of her, but I'm going to try to find something else just because that was 100. Right now I'm paying 50 an hour. At the first visitation facility, they were charging 100 an hour, and I can't afford that.
Okay.
I believe Barbara was $50 an hour, and a Parents Place is $25 an hour.
Is it? Okay.
All right, Mr. Kyoshi, I'm going to leave it to you to get a hold of Ms. Brandhorst. Okay. Sounds like Sunday will work, and it sounds like more time will work, and I'm in favor of all of that. Okay.
Yes, sir.
All right. So we'll be back here on June 28th. If there's some glitch, I guess, in the supervised visits, you can note this for a hearing before June 28th so we can address it. But I'm hoping everybody can work together to make this work. Okay.
Your Honor, if I may.
Yes, please.
The GAL fees that the father owed, $550.
Yes, I'm sorry I didn't address that earlier. Mr. Kyoshi, any comment on that? That needs to be paid.
It will be paid, Your Honor. I have a lot of bills. I thought we just got the child support set up, but I guess it's not finalized yet. I'll pay. I'll get it paid.
All right. I would like that paid by the next time we get together. Okay.
Yes, Your Honor.
Thank you, Your Honor.
All right.
I'm here,
Thank you,
Your Honor.
Good to see you. All right. Is Mr. Wayan here? If you're on the phone, Mr. Wayan, you need to probably press *6 to unmute yourself.
I do see his phone number there, Your Honor.
Is that 2750?
Yes.
All right. Mr. Wayan, can you unmute yourself so I can hear from you?
All right.
And Your Honor, if I may speak before we begin.
Yes, please, go
on behalf
ahead.
of the State Division of Child Support. The child is receiving TANF in Washington, so we will be filing a notice of appearance, but we had a couple of concerns we wanted to discuss prior to the hearing. We're not able to see the acknowledgement of parentage that was filed on March 3rd because we don't have our notice in yet. But we did notice a potential issue with parentage being legally established, as it looks as though genetic testing was done in Oregon, and the child may have been born in Minnesota. So we don't know if the paperwork was sent to the correct place to have a birth record legally put in place. And we also are not sure how long the child has been living in Washington State. It doesn't look like there's been a direct hearing for this case yet, and it is set for a settlement conference next week at 9 a.m. on the 8th. So we just wanted to bring those things to the court's attention at this time.
So Lincoln was born in Minnesota. The CPS case that closed, and he was returned to me on April 28th or 24th of this year, but he was in Oregon prior to that. They did establish paternity in Oregon through DNA testing. Oregon Department of Human Services did that. I can have them send that to you guys if that's something that would work, or do we need to establish again? I don't understand what needs to be done.
Your Honor, that was our concern, is that genetic testing did establish biological parentage, but legal parentage hasn't been established yet. It doesn't appear. Oregon can't do a birth record. Minnesota would have to do that if that's where the child was born. So paternity does need to be legally established before we can move forward with this case.
I don't know how to go about doing what you're saying. I'm sorry.
It's understandable. It's a complicated process, but Your Honor, because the child is currently living in Washington, we can look into here in Washington being able to file a parentage action. We would have to do new genetic testing, but we could establish parentage here in Washington State. Our only concern was regarding the length of time the child has lived in Washington, as this may not yet be the home state for the child.
How long has the child been in Washington?
Only since April 24th or 28th. I can't recall when they closed the CPS case in Oregon.
All right, and I believe Washington doesn't acquire jurisdiction until after 6 months. Okay. So that means another state actually has jurisdiction over the child. It sounds like it may be Minnesota. And what Ms. Looney, I think, is saying is they can't go forward unless there's a parentage action, legally established parentage. If we want that to happen in Washington, we're gonna have to wait until the child's here 6 months, and then Washington will have jurisdiction to do the genetic testing.
Okay, that makes sense. Does that push out the mandatory settlement conference and everything until he's been here for 6 months?
Your Honor, we wouldn't be able to do anything regarding parentage without legal parentage, so we wouldn't be able to have a settlement conference for this hearing today.
Okay.
That would probably push that out.
Okay, I will look at the date that he came back into Washington, and I will reschedule all the hearings for 6 months out from then.
Okay. You've also brought a motion for a restraining order, so I'd like you to address that. I know a temporary one has been entered at this point, but why don't you address your request for a restraining order, and then I'll hear from Mr. Wayan in response, okay?
Okay. My initial concern was in Lincoln being returned to my custody. Jacob was not happy about that. And he had made threats to go over to the resource parents' house, the foster parents' house, to see Lincoln, which is not something that he legally can do. And so I was unsure if when Lincoln came back to my custody, if Jake would also try to see Lincoln and disturb our peace when he was not welcome to do so. Oregon never approved Jake for anything beyond supervised visits within their CPS facility due to questionable parenting and abilities. So I wanted to make sure that he didn't try to see Lincoln outside of a supervised situation.
Oregon had their CPS was involved, as I understand it. Is that right? And that's been dismissed now?
Dismissed, yes.
And why was it dismissed?
Because I have completed everything that I needed to complete in order to have Lincoln returned to me.
Okay. Okay. So part of that CPS case dealt with you, I guess, or dealt with both of you?
The entire thing started with me. Jake has never known Lincoln prior to that case being opened. The only time he's ever seen Lincoln would be through Oregon CPS. So he's never seen Lincoln outside of that. The case wasn't open because of anything he did, but there were very many concerns once he started seeing Lincoln there.
Okay. And Lincoln's living with you now?
Yes.
Okay. And I don't want a specific address, but what are you in the Cowlitz County area?
I'm in Cowlitz County, yes. I just recently moved, but I'm still in Cowlitz County.
Okay. And where does Mr. Wayan live?
On Oak Street in Longview.
Okay. So he's in Cowlitz County too?
Yes.
Okay. So you're asking, well, what Oregon DHS had was 2 hours a week supervised. Is that what you're suggesting the court?
Yes. I am also willing to get together with them in a public place so he can see Lincoln. I've been trying to, prior to the case closing on him making those threats about the foster parents' house, I was trying to meet with him to figure something out so he could still see Lincoln as long as it was either with me or with a supervised visit professional. But I'm willing to do that, but he wouldn't talk to me about it.
Okay. All right, Mr. Wayan, any response? And just let me know what you'd like to see happen.
Yeah, the way this went down is, well, the thing is Lincoln was taken away from Kendra and in Oregon. They found meth in the system and stuff. And anyways, I heard that she signed her rights away and he was going to be adopted. So I called Oregon and told him I wanted a DNA test done because I thought I was the father. And it took them 5 months to finally get me a DNA test in Oregon. You know, they just kept putting it off, it seemed like. And finally, when I established the DNA test, I said I want my son. And Kendra is on probation for child endangerment of Lincoln. And so, anyways,
Miss Despain, let's let Mr.
Sorry.
And speak. Okay, go ahead, sir.
And so, anyways, so I said I wanted my son, and I never put my son in any danger or anything. And what happened is when I went to court, my lawyer told me that I need to answer the questions yes, and or I won't get Lincoln. And the one question was that father has a history of unrehabilitated substance abuse that puts the child at risk. And I answered yes to that. I didn't really, it was the first time I ever heard that question, and that's why I wasn't able to get Lincoln, and I got like sucked into this whole process and stuff. But I've never put him in danger or anything like that. And I haven't been able to spend any time with my son. I haven't seen him since in over a month now. And I think the restraining order is like ridiculous. I've never hurt Kendra or anything like that or attacked her. We did get in a fight, but she was the aggressor in that, and she's been charged with a 4th degree assault and 3rd degree mischief. But I wasn't the aggressor on that. She was, and
she indicated you threatened to take Lincoln from the foster parents.
No, I just sent a text because I was court ordered to meet the resource parents, and they didn't want to meet me for some reason. I don't know why. And so anyways, I sent Nicole a text just saying like, oh, I'd like to see Lincoln, because my visits were getting canceled. I only saw Lincoln like 6 times in the last 5 or 8 times in the last 5 months, and so my visits were getting canceled all the time and stuff. And I just I wasn't a threat or anything. That's blown way out of proportion about me threatening or anything. My visits are getting canceled, and I haven't seen my son at all hardly. And I never put him in danger or anything like that. I never put him at risk or anything.
What's your position on meeting at a public place for a few times? I think
that's a little overboard. I think that's kind of ridiculous. I mean, I got a house here, and I got a room for him. He's never been to. I want him to come to see his room at his house, and I want to spend time. I want to be involved in my son's life. I want to be a part of it. I have a lot to offer him. And I don't think I need supervised visits. I just did like a 1.5 years of supervised visits over in Oregon, and I don't know why I would need supervised visits.
So let me speak a minute. I just got this case and reviewed it, and what the information I have is that you've gone through. You were only given 2 hours a week of supervised visits in Oregon. I'm not sure why, but the court had some reason for that, or DHS did. And then another judge in this court entered a temporary restraining order restricting your access to Lincoln. So I come here, and you're saying, well, all that's ridiculous. I should just throw that out and let you have unsupervised visits. I've got too much information here to allow me to do that. So it seems to me that a good first step would be for you to cooperate with seeing Lincoln with Kendra at a public place to see how that goes.
Okay, yeah, I'd be open for that. Yeah.
All right. Ms. Looney, did you want to say something?
Yes, Your Honor, if I could. I'm not sure if Washington has jurisdiction at this time to establish a visitation schedule for Mr. Wind. As we don't have parentage, we can't make any decisions about a parenting plan or parenting time. So we may need to restrict this just to a restraining order and distance at this point.
Okay. Thank you for that. I think that's well taken.
I would be willing to drop the restraining order and just Jake and I can work out something to go see Lincoln at a park if that's all right with you, Your Honor, and then we'll continue with documented visits and things like that after the 6 months.
Okay. All right. Based on that and based on what I've heard today, I'm going to I guess I'll deny the restraining order without prejudice. I won't prevent you from bringing it if you need to.
Thank you.
I cannot enter a temporary order. I can't do much of anything else.
I understand.
At this point because of the jurisdiction issue. So
I understand.
All right.
Your Honor, before
well-
we go, if I can just ask Ms. Despain to call our office so we can get her new address. We don't want her giving it out over Zoom or anything. But our
Absolutely.
number, make sure you get our correct our information when we file paperwork to be involved in the case.
Okay, sounds great. I will do that. Thank you.
So, Mr. Wayan, what's happened is I'm not entering a restraining order. So there will be nothing, there just won't be a restraining order. And I encourage you and Ms. Despain to work together to work out times when you can see Lincoln. Okay.
All right. Thank you.
All right. Thank you both.
So there's no restraining orders in. They got dropped.
Right. The temporary one will expire today, and I'm not going to enter a new one.
I will call you, Jake.
All right. Thank you.
Thank
All
you,
right.
Your Honor.
Thank you.